All right, sir, you're trailing Hill?
Yes, ma'am.
And Mr. Hill, in cause number 24, DCCR 1500, you're charged with obstruction or retaliation, which is a third-degree felony from June 2nd of 2024. What that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yeah.
And then in cause number 24, DCCR 1614, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon. That's from July 15th of 2024. And what that means in that case is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
I was notified.
I'm sorry?
I was notified. Yes, ma'am.
Okay, I just need to make sure you understand, just yes or no, okay?
Yes, ma'am.
Cause number 24, DCCR 1615, you're charged with aggravated robbery from July 15th of 2024. That's a first-degree felony offense, which means if you go to trial and you're found guilty, the range of punishment is between 5 years and up to 99 years or life. Do you understand?
Yes, ma'am.
And then finally, in cause number 25, DCCR 0436, you're charged with a second-degree felony offense of burglary of a habitation from June 19th of 2024. That means that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
In all of those cases, I have here on the tablet some documents that you've signed with Ms. Perazzo that shows that the district attorney's office has made offers if you wanted to enter pleas of guilty in your cases for a 15-year cap on the aggravated assault, aggravated robbery, and burglary of a habitation, with a dismissal in the obstruction or retaliation. So that means you would be leaving your punishment up to me in those 3 cases. And if I followed the agreement, I could not give you more than 15 years. I can give you 15 years. I can give you less. It would depend on information that was brought to me at a sentencing hearing. You have every right to reject that and have your cases go to trial and let a jury decide if you're guilty or not and what your punishment is if they find you guilty.
Okay.
Is that what you want to do? Do you want to reject those offers and have a jury decide?
I'd rather reject the offer because I feel like it would be a better choice for me in the process.
Okay. So what I'll do is get your cases set very quickly for trial.
Yes, ma'am.
Mr. Nichols, what is the state's position with regard to which case or cases would be?
I expected to proceed on the ag robbery, Your Honor. It's the same incident as the aggravated assault. I may join them.
Okay,
But I tend to go forward on that case first.
All right, ag robbery, possibly the same one.
And I know that with the age of these cases, even on its first setting, it should expect to be breached, Your Honor. So we'll be ready for trial.
Okay, perfect. Same thing. Obviously, I've asked Ms. Perazzo to get up to speed very quickly on these.
Yes.
That first trial setting is likely to be it going. So we need to get these taken care of and Mr. Hill either out of jail or on his way somewhere else.
Yes, ma'am.
All right. Okay. We'll set them for trial. You can go back with the bailiff.
Thank you, Your Honor.
Mr. Hill, wait real quick before you. I do also want to make sure you understand that after today, I will not accept these agreements. So we'll put your case on the trial docket. We'll get it tried very quickly, but you're not going to come back in later and change your mind unless it's to something different than what the offer is today. Do you understand?
Yes, ma'am. I'm trying to get, after paying Mr. Burbank that much money, I was hoping I could have got a better offer in the process.
Well, this is what the offer is. The offer is not going to change. So I want to make sure you understand that holding out till trial or anything like that is not going to get you a better offer.
Yeah.
This is what the offer is. I'm not going to accept it after today. You understand?
21 hearings, yeah.
All right, go back with the bailiff. Okay, I guess just obviously by what I'm looking at, that seems, am I looking at the right thing? Dakota Chapman? The first violation is that he committed the offense of murder?
That has been abandoned.
That was not.
Yeah, go.
Okay,
I'm sorry.
thank you.
We should have started with that.
We're just gonna go to safety and,
No.
okay.
That
So,
was done in December.
let's do this. I'd like to go ahead and go through the motions, get pleas of true or not true to the remaining counts. And then obviously if you guys have an agreement, we'll look at that, but I think I want to go through and have those pleas on here.
And that came at the recommendation of his supervisor, who
Okay.
I'm sure has much more information for the court as well.
That's good. Thank you. If you want to print this section, I'll just do the first one on here. All right, will he waive the formal reading of the motion in each case? Mr. Chapman, in clause number 23, DCCR 1077, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation May 6th of 2024 for the offense of evading arrest or detention with the use of a vehicle, a third-degree felony, and that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
And then in clause number 23, DCCR 1078, I also have a motion to revoke your unadjudicated probation. This shows that you were placed on probation May 6th of 2024 for the offense of accident involving injury, a state jail felony, and that was a 5-year deferred probation. Is that also correct? And so the state is going to abandon each case count 1, correct?
Correct, Judge, based on the comments of the grand jury.
So, Mr. Chapman, in each case, the motions allege you violated your probation. Count 2 in each case alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? Count 3 in each case alleges that you provided a urine sample March 12th of 2025 that tested positive for cocaine. Is that true or not true? Count 4 alleges that you provided a sample September 3rd of 2025 that tested positive for methamphetamines and amphetamines. Is that true?
True.
Count 5 in each case alleges that you admitted to your probation officer to using the illegal drug ecstasy December 3rd of 2025. Is that true or not true? I'm sorry. Count 6 alleges in each case that you were at a location other than your residence at approximately 1:53 a.m. December 21st of 2025. And is that true or not true?
True.
Count 7 in each case alleges that you failed to successfully complete the defensive driving course as ordered. Is that true or not true?
True.
Count 8 in each case alleges that you were behind in your court assessed fees. And is that true or not true?
True.
Did you enter your pleas of true in each case to counts 2 through 8 freely and voluntarily? And did you plead true to those counts because they're actually true? So it's my understanding, Mr. Chapman, that the recommendation is that I continue your probation and order you to enter and successfully complete the special needs safety. Is that your understanding?
Yes.
Is there any reason to get any type of pre-sentence report or update?
Only at the court's discretion, Judge. The officer, Ms. Falier, has already prepared for the court the continuation and modification of that special condition if the court would like that to be signed off on today. Otherwise, I'm sure she'd be happy to do a quick update.
If it's her recommendation, we'll just go ahead and go forward. So
I think that was, I'm sorry to interrupt, I think that was done prior to count 1 that we see, which obviously caught everyone's attention and just took that immediately off the table. But
Right.
since that was no build, I think that's when she finds herself back in the same position.
So, Mr. Chapman, you're getting your second chance today.
Yes, ma'am.
There's not going to be a third. Okay. You need to take advantage of this. I don't know what happened. The night of December 21st of 25, obviously it was no build as far as the offense, but you were clearly somewhere you shouldn't have been doing some things you shouldn't have been doing, right?
Yes.
If you had been home during curfew, you never would have been charged with anything. There wouldn't have been any issue of whether or not you did anything, right?
Yes, ma'am.
So I want to make sure you understand if I go along with this and send you to safety, you're going to get some tools so that you can hopefully stop using drugs, do the right thing, live your life like the rest of us and not end up in prison. Do you understand all that?
Yes, ma'am.
All right. So at this time in each of your cases,
I don't know how the court would feel about an extension, Judge, based on the age.
yeah. So at least in the evading,
Okay.
I'm going to do that. We're going to talk a little about the jail incident reports as well in just a
Yes,
minute.
ma'am.
So I'm going to find in each of your cases that you entered your pleas of true to counts 2 through 8 freely and voluntarily. Find those counts true, find sufficient evidence in each of your cases to revoke your probation. But I'm going to go along with this agreement today, and I'm going to continue your probation in each of your cases. In clause number 23 DCCR 1077, I am going to extend your probation by 2 years. And I'm going to order in each of your cases that you enter and successfully complete safety. That obviously means going through the program in custody, but it means getting through the aftercare and everything else successfully. If you do all of that, then you're still on these deferred probations. You still don't have felony convictions on your record. This is, again, the opportunity of your lifetime right now for you to make the changes and do the right thing. If you don't, and you come back in here, then you are going to end up with 2 felony convictions, and you're going to end up going to TDC for up to 10 years in one case and state jail prison for up to 2 in that case. Do you understand?
Yes, ma'am.
Let me explain something else. I am also now making it a condition of your probation that you treat the staff and the correctional officers at our jail and at Safety and wherever you are with respect, and you follow all of the rules when you're incarcerated. That means if I get another incident report before you get to state jail, before you get to Safety, it's already a violation of your probation. They're going to let me know, and you're never even going to make it to Safety. You're going to be right back in here and looking at going to prison. Do you understand?
Yes, ma'am.
So the way you're talking to them at our jail, you cannot keep doing that. You cannot keep arguing. You can't keep fighting. You can't keep saying, F that, I don't care, things like that. Okay. And you're looking at me like you're confused, that maybe you didn't do these things, but this is what I have. Every time you act up, every time you tell someone, if you're going to send me out, just do it, F that, or whatever it is, that's disrespectful.
Yes, ma'am.
All right. They're just trying to go there and do their job every day. Hopefully someday that's what you want to do. Get out of jail, go to work, and not have somebody treating you like this when you're at your job. Right?
Yes, ma'am.
All right. So you'll sign some paperwork today for Safety, and I think that's it as far as adding the condition. So add 2 years in the one case and the condition with regard to being successful and not being disrespectful.
Yes,
Okay.
ma'am.
All right. Good luck to you. You can go back with the bailiff. Here's that.
A courtroom warning turned into a defining moment as 2 defendants faced very different futures before Judge Raquel West. First, a man charged with aggravated robbery, aggravated assault, burglary, and obstruction stunned the courtroom by rejecting a plea deal that capped his prison exposure at 15 years, choosing instead to take his chances before a jury. Judge West made it crystal clear. Once the offer was gone, it was gone for good. Then came a probation violator whose record was filled with failed drug tests, curfew violations, missed requirements, and repeated bad decisions. Despite enough violations to send him straight to prison, the court chose rehabilitation over punishment, granting one final opportunity through an intensive treatment program. But the warning was unmistakable. This was his last chance. Throughout the hearing, Judge West emphasized a message that echoed through the courtroom. Second chances only matter if they're taken seriously. One defendant gambled everything on trial, while another narrowly avoided prison after nearly throwing away his future. In the end, the question wasn't about guilt or innocence. It was about choices. When the justice system gives you one final opportunity to change your life, do you fight for it or risk losing everything?